For liberals and for a lot of Democrats, the 2008 election was a little bit of a mixed bag. I mean, on the one hand, there was a huge amount of euphoria about a man named Senator Barack Obama winning the presidential election against John McCain. That was very exciting and a very big deal for liberals and Democrats and for a big swath of the country. Less exciting, though, that night was what happened in California. California passed Proposition 8, which took away an existing right. Before Proposition 8, same-sex couples had the right to get married in California, and thousands had done so. Prop 8 rescinded that right, which made for a bittersweet election night and made for a little bit of confusion in the late-night coverage that night.
I believe we've got some pictures out of San Francisco as well. Some of the celebration pouring out in the Castro district of the city, as it's known. A place near and dear to your heart,
to
Chris
me,
Matthews.
Certainly me, having written for the papers out there all these years.
That may not all be celebration if it's in the Castro and we haven't got the results of Prop 8 yet. Prop 8 passed in California in 2008 that rescinded same-sex marriage rights. But it was soon challenged in court by a very famous odd couple of very, very big deal American lawyers. The two most famous litigators in the country. David Boies had been Al Gore's lawyer in Bush v. Gore. Ted Olson had been George W. Bush's lawyer in that same case. Ted Olson went on to become Solicitor General in the Bush administration. A conservative icon and a liberal icon fighting on the same team. They won their first round in federal court with a ruling that Proposition 8 was unconstitutional. That was appealed up to the Circuit Court, which is just one level below the U.S. Supreme Court. Today we got the ruling from that Circuit Court. They found on very narrowly construed grounds that Proposition 8 does violate the United States Constitution. It is unconstitutional. The court found that Proposition 8 served no purpose and had no effect other than to lessen the status and human dignity of gays and lesbians in California. Joining us now for an exclusive interview is one of those two very famous lawyers who got that big win today, former Solicitor General Ted Olson. Mr. Olson, congratulations and thanks for your time tonight. Nice to see you.
It's my pleasure to be here. Thank you, Rachel.
I am no expert on these matters, especially compared to you, but the ruling seems to me narrowly construed to apply just to the situation in California, to not try to assert a right to marriage equality more broadly. Is that the way that you see it, and did you expect it to come out that way?
Actually, I think it's a very broad decision, and let me explain that. In the first place, the court said that California was somewhat unique in that, as you said a few moments ago, Proposition 8 took away the rights of same-sex persons to get married. But the right exists in many other states now, and people are attempting to take that right away in other states. And therefore, this precedent stands for the proposition that once you grant those rights, people have the right to get married, which is a fundamental right in this country. You cannot take it away from those individuals without violating the Constitution. But the court went on to stress, with respect to various other issues in the case, that there was no justification, there was no rational basis to single out gay and lesbian individuals in this country and take away rights from them or to deny rights from them. The court went through every argument that had been made on the other side and systematically dismantled every one of those arguments. So while the court focused on the peculiarities of California, the principles it articulated are quite broad and very compelling.
When you say that the court asserted that you cannot take existing rights away, but also that you cannot deny rights to couples on the basis of sexual orientation, does that mean that you see this as potentially potentially blazing a legal trail for states in which there are not same-sex marriage rights recognized right now?
Oh, absolutely. Because what the court relied upon was a major decision by the United States Supreme Court called Romer versus Colorado, in which Colorado had restricted the rights of gay and lesbian individuals, and the Supreme Court of the United States struck that down as unconstitutional. But both in that Romer case and in this case today, the court said if you're going to select a class of our citizens, these are our citizens that are presumptively entitled to be treated like other citizens, and select them out on the basis of characteristics that are peculiar to them, you have to have a reason for doing so. And the reasons that were articulated by the proponents throughout this litigation were found completely lacking by the Ninth Circuit and the court below it. And so those principles are going to be very important for states that have not yet recognized a right for individuals to get married to the person they love who happens to be someone of the same sex. The United States Supreme Court 40-some years ago struck down a similar prohibition that existed in 16 states that prohibited people from different races from getting married in a case called Loving versus Virginia. 16 state laws were wiped out, laws that would have prevented the President of the United States, his parents, from getting married in Virginia in 1967. They would have been guilty of a felony. This decision is very much like that decision.
You were clear from the beginning that you wanted a case that could win at the Supreme Court. You wanted a landmark case. Now, as I'm putting words in your mouth, you don't speak that bluntly, but could this be that case? Do you see this as the likely path forward in terms of what the Supreme Court decides to take up?
We very much thought that this was an important case that could go all the way to the Supreme Court. The plaintiffs in this case are individuals who have been in relationships for a long period of time, loving individuals. The lesbian couple have 4 boys that they're raising in a wonderful household. The trial had 8 expert witnesses testifying about history of discrimination, what it's like to be gay, what it's like to be denied the right to marry. The district judge rendered a meticulous, thorough decision, and the Ninth Circuit did so. This is the issue that should go to the United States Supreme Court someday. The people that we're representing and others like those people are not asking for anything special. They're asking for the right to be treated with decency and respect and dignity and afforded the same rights that we afford to other citizens in this country. They're not asking for much, just equality. And I do think this issue will go to the Supreme Court. I think it will go to the Supreme Court in this case, and there could not be a better record or a better foundation for this important principle to get to the Supreme Court.
Hearing you speak about it in those terms makes me want to, I guess, put a question to you that will require a little extrapolation. The Mormon Church was the main financial backer and the main provider of early volunteers to the Proposition 8 effort. All the Republican candidates for president, except for Ron Paul today, put out statements deploring today's ruling, which, of course, went your way. As a conservative, as somebody who's been so important in conservative politics, why do you think it is that hostility to gay rights is still something that is so utterly mainstream and expected of both mainstream politicians and mainstream institutions in conservative politics today? Well,
I don't know the answer to your question, Rachel, but I think it's terribly unfortunate. Marriage is a conservative value, not that conservatives own it or liberals own it, but the loving relationship between individuals that want to be respected by their society and treated as equals is a conservative value. It involves liberty and privacy and association and identity. Marriage is a building block of our society. Young people get it. Older people are still getting it. But all of the polls are changing. People more and more are understanding that these are our American citizens. These are our brothers and our sisters. And we have got to treat them right, and we've got to treat them decently, and we've got to give them the same freedom and justice that we give to other people. More and more people in America are understanding that. I'm pleased to say that more and more Republicans are understanding that. I'm sad to say, it makes me sad to say that Republicans haven't fully understood it. But I think the day will come, and every time that we have a chance, David Boies and I have a chance to address this question, we believe we're converting more people and persuading more people that this is the right thing. It is not a conservative or a liberal issue or Republican or Democrats. When David Boies and I came together on this, our mission was to persuade the American people that this is an issue of American justice, American freedom, American equality. These are the principles. All men are created equal in this country. We have got to get there.
Ted Olson, former Solicitor General under George W. Bush, the attorney for plaintiffs challenging Proposition 8, along with David Boies. Thank you so much for joining us tonight again, sir, and congratulations on your win today. I really appreciate being here.
Thank you so much, Rachel.
Thank you.